Welcome to Ties That Bind Law, Family, and Legacy.
Welcome back to Ties That Bind Law, Family, and Legacy with Patti Garner. Patti is a Tennessee attorney who focuses on estate planning and probate, helping individuals and families make clear, thoughtful decisions about the future and avoid unnecessary complications down the road. With over 20 years of legal experience, she brings a straightforward, practical approach to these conversations. I'm Shameika Rhymes, and today we're talking about what documents actually make up a complete estate plan in Tennessee. Welcome back, Patti.
Hey, Shameika, thanks for having me.
Well, Patti, what makes up a complete estate plan?
Wow. So, a whole plan, when we put together a plan, it includes a trust document, it would include a will, it would include a durable power of attorney, it would include a healthcare power of attorney, also an advanced healthcare directive, which would determine whether or not you're on life support or that kind of thing. You go ahead and identify whether you do or don't want to be on that. It would include all of the certificate trusts and all the things that you would need for your plan to be perfected and to be accepted in the business world that you might need to use it in. It would also include an area for you to self direct where you want your personal belongings to go to. So anything that's titled can be moved around by the trustee. But where is the dining room table or where is mom's wedding ring going? Those are the kind of things that are personal and don't have title. And we would include a document for you to be able to make those decisions and change that as frequently as you wanted to.
Well, how does a will fit into that overall plan and what does it actually control?
So the will is, so let's say you set up a trust in your whole estate plan and you don't get back to updating it. And so you've bought another piece of property and you didn't title it correctly. Or the couch that's in the living room needs to be transferred and it didn't get into the trust. The will would handle all of those kind of little bitty things that would then be moved over to the trust or the estate. Now, absent a trust and a whole estate plan, if you have a will, that's simply an entrance into probate court so that, we go in, we probate the will. Hopefully, we get to do what the will says and everything gets distributed the way you wanted the will or the way you wanted in the will.
Well, Patti, what is a durable power of attorney and when does that document become important?
So, a durable power of attorney is the document that allows the person you choose to make the decisions about businesses, about insurance policies, about all of the things that go about making up the business of you. So that they can make decisions, they can enter into and access sometimes checking accounts, savings accounts, life insurance policies. It depends on how powerful the durable power of attorney is. When we write them, they're very powerful. They become effective either upon signing or upon your incapacity. And it really depends on kind of where you're at and how you're using it or how you intend for it to be used. They're very special documents. You want to be careful as to who gets access to it and who holds it. What I tell people is, let's create it. Let's you hold it in a very special place, usually in the lockbox or the safe. And then when it's needed, the family could get access to it and the person could act on it.
What is a healthcare power of attorney or advanced directive cover and how is that one different?
So the healthcare power of attorney is the one that allows somebody besides you to make the decision about whether or not you want to be on life support, whether or not you want to donate your organs, whether or not you want to undertake many different medical procedures. Let's say you have a stroke and you're not capable at that time of making the decision. The person that you've appointed can then take their power of attorney and go to the emergency room and say, "Oh, I'm here. I'm mom's power of attorney. And this is the way we need to proceed because this is consistent with her wishes."
So with younger people now seemingly having strokes and heart attacks, even in their 20s, should they have one of these healthcare power of attorney or an advanced directive?
Absolutely, they should have one of those. So a funny story, I was thinking about a young person having a power of attorney. My youngest son graduated from high school at the age of, he was almost 19 by the time he went off to college. He was only going 2 hours away, but he played sports. Well, in the event he's 2 hours away and somebody needs to make a decision, or 6 hours away on a college bus because they've carted him off somewhere across the United States to play ball, I the first thing I did is I was like, "Okay, kid, I understand you're an adult, but there are things that I'm gonna need to be able to do for you as a young adult to help you. You gotta sign this power of attorney so that I can do those things." So we had a power of attorney party at the office where all of his baseball player friends showed up at the office, and we signed up all the mamas and daddies so they could do that, and you don't think about those kind of things when kids are going off to college. You don't think about the 25-year-old having a stroke or doing something where they need that kind of assistance. So I think it's very important to think those things through.
Well, where do trust come into the picture, and in what situations do those make sense?
So, trust really are powerful tools, and they can be used as asset protection. They can be used as the family dynasty protection. It really depends on the way you create the trust and how you want to utilize it. It can be it can be a holding trust. It can be an operating trust. There's a variety of different ways, and that's why it's so important to sit down with an estate planning attorney, like myself, who understands how you use them and put them into play. One of the most fascinating aspects of a trust that I find is how you create and build generational wealth within that trust, and you protect all the members of the family, for years to come, and they don't even know. But, if you've done it and you do it well, it's a beautiful document that really protects and builds a family.
Where do you see people leave gaps when they try to put that estate plan together on their own? Like maybe they're using some AI app or, some other app they've heard about. Where do you see people leave gaps?
So when you create a trust, you have to do, and to perfect it and do it well, you have to do what's called funding. And that's a real complicated term, sort of sounds like. But essentially, what it means is we've transferred our personal property into the trust. And when you do it on your own or do a DIY kit, that's where I see it fail. They've
Mhm.
created a trust document, they've had it signed, they've done all the things, but then they move the property into the trust. And when you fail to move it into the trust, or you fail to change the owner of the insurance policy or the owner of the bank account, then you haven't properly funded your trust, and it creates a nightmare. I'm working on one now where mom and dad and their 10 children. Mom passed and then dad passed in very short order. And between one passing and the other passing, they didn't get all the insurance fixed the way it needed to be fixed. And, the first one that passed, there wasn't much left for an estate. But the second one that passed, because they hadn't fixed the insurance and hadn't fixed the bank accounts, we actually ended up, although there's a trust, we had to go and probate so that we had the power to do the things with the insurance policies because they didn't own them properly. So it wasn't structured into the trust.
How do these documents actually work together when something happens and they need to be used?
So the power of attorney would also include, let's say, a conservator appointment. And so let's
Mm.
talk about the stroke scenario. You've had a stroke, you're in the hospital, you're in the middle of a crisis. Especially if you're an unmarried person,
Mhm.
somebody has to make a decision. With the power of attorney and the conservator already having been appointed, then that person's going to immediately be able to go in, talk to the doctor, say, "Hey, I've got the document. Here it is. I need to be the one to be able to be point of contact so that I can make these decisions, and I'm who you need to talk to when those decisions need to be made." If you're talking about, a business decision, then that's gonna be covered under the regular durable power of attorney. So, mom's had the stroke, and somebody needs to be able to operate the business or write payroll checks or any of those kinda things. Then they would take their, power of attorney, they would go to the bank and do the things that they need to do to operate under that document.
Okay. So if someone doesn't have any of these things in place and they have a stroke, then what?
So that's what I call crisis situation because then you're in the especially in the state of Tennessee, you've got to file, sort of an emergency request for a conservatorship. You've got to, get to court. A doctor has to fill out, the physician's form. Within 5 days, you have a court hearing. There's been an attorney a guardian ad litem appointed, perhaps an attorney ad litem appointed, and we get to court. The court then makes the determination as to whether or not they want to appoint, sister 1 or sister 2 as to be the person. But by the time you get there, we've now run up $5 to $7,000 worth of attorney's fees just to get the appointment order. Then we have to do a property management plan. We have to have regular court appearances. You would have to determine whether or not that's going to be a temporary conservatorship or if it's going to be long term. And again, each one of those court appearances runs up an attorney's fee bill.
So it's cheaper to go ahead and put this complete plan together.
So it is. It's one of those things. And I know when you think about doing a complete plan, and those prices run depending on what you're doing and how you're funding and all the things. On average, I would say they run between $3,500 and $7,500. Again, it depends. It's very fact specific. Um, but you're either paying for it now or your family's going to have to foot the bill when the time comes, especially if you're in an emergency.
Well, what difference does it make for a family when everything is properly in place versus when it isn't?
Oh, wow. When it's properly done, it is a cakewalk. You may have to move some vehicles around, which would require some court action. You may have to, it would be very minimal court involvement. It would not be long lag time, and it would be quick and easy moving on to the next phase of what we have to do.
Thank you so much, Patty, for breaking down what a complete estate plan looks like. So it definitely sounds like it is cheaper to just go ahead and put that together versus dealing with the crisis later on. So thank you again for joining.
Absolutely. Thank you. I appreciate you.
Well, that's it for today's episode of Ties That Bind Law, Family, and Legacy with Patti Garner. If you have questions about your own estate plan or you want to make sure you're making the right decisions for your family, you can reach out to Patti Garner at Garner Law Firm by visiting pattibgarner.com. Thanks for listening, and don't forget to like, subscribe to the show, and leave a review if you found this episode helpful.
Y'all give me a call and let's plan your legacy.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.